We'll resume the hearings, and I now welcome via video and teleconference representatives of the Australian Brotherhood of Fathers, Mr Erikson, Mr Beck, Mr Bowshire and Mr Jose. For your benefit, Chair Kevin Andrews, I'm joined by the Deputy Chair, Senator Pauline Hanson, Dr Ali, Dr Martin, Mr Perrott, Senator Polly and Ms Stegall and Senator Waters. For the Hansard record, could I ask each of you to state your full names and the capacity in which you appear today?
Leith Erikson is my name. I'm the founder of the Australian Brotherhood of Fathers.
Cody Beck, I'm the Director of ABF Legal.
Tyler Bowshire, I'm a solicitor at ABF Legal.
And I think we're waiting for one other that was appearing from Melbourne or Victoria via video link.
Right, we might proceed if that's okay because of the timing.
Sure.
We can make that connection. We will make that connection, obviously. For the you've lodged submission number 1668 with the committee. Are there any amendments or additions to that submission?
Not at this stage, no.
And information on parliamentary privilege and the protection of witnesses and giving evidence to parliamentary committees has been provided to you as part of the invitation to appear. The members of the committee have your submission, but can I invite you to make a short opening statement and then we'll come to questions.
Thank you, I will. Thank you. I'm pleased to be here. Initially, I'd like to acknowledge my children, Ethan and Lachlan, who have grown into young men without access to their father. I'd also like to acknowledge Nathan Cattins and his mother and the grandmother of a child, Isla, that was recently murdered in a family court matter. Also an Aaron Cockman from Western Australia, who was a father who's lost 4 children because of a family law matter. James McLeod, who lost 4 children in Queensland just recently because of a family law matter. And Sue and Gary Cook, who are the parents of a Carl Cook, who was connected to us and has recently taken his life, being involved in a family law matter. I'd also like to welcome and thank the many fathers and their families who've supported the Australian Brotherhood of Fathers over many years, some of them who are behind us, who have been through the domestic violence system and the family law system, spending many hundreds of thousands of dollars. I'd also like to thank the Prime Minister for making this inquiry happen. A quick introduction in regards to the Australian Brotherhood of Fathers. I founded the organisation 8 years ago after dealing with my own personal issues with domestic violence and family law, child access and child support. We believe that if we ran campaigns that would connect with the community and speak to our political leaders, that we would see some reforms that would help us co-parent post-separation. It's been a long journey for us. Through that period, we've run campaigns where we've talked about male suicide. We've talked about the failures of the system to provide support services for fathers and their families. And we've talked about the importance of accessing qualified legal advice through the domestic violence courts. We've also set up a number of services where we provide support directly with crisis accommodation, court support programs and a national free call number, 1-800-FATHER. We're also privileged to have started our own law firm simply because we're seeing over many years the system, the political system and the legal system not delivering the necessary services that we desperately require when relationships end and families are forced into the family courts. One of the focus points I wanted to introduce you to is what we believe is a failure of the domestic violence system in Australia to acknowledge male victims of domestic violence. We see that as a significant issue where fathers at the end of their relationships will often find themselves exposed to police and the courts, leaving them in a position where there are limited services that they can access, which can force them into long periods of no access to their children and place them in a position where they're deemed a perpetrator because their relationship ends. And then when they enter the family law system, they find themselves on the back foot. So it's been very challenging for us and we're really privileged to be here. I would happily open up to questions from the committee in regards to our submission.
Thank you very much for those opening comments. And as I noted before, it's a very detailed submission, so obviously we won't be able to ask questions about all of it, but this is just to, the hearings that help us to tease out what are in written submissions. They're not a substitute in themselves for the written submissions. So if I can therefore lead off in relation to some of the matters, and then I'll go to Senator Hanson next. In terms of your recommendation number 7 in the creation of an alternative non-adversarial model, which you talk about convening a cross-stakeholder and advocacy group to develop a non-adversarial model, do you have any ideas or any suggestions about the framework of that model, what it might look like, how it might work? Are there other jurisdictions elsewhere in the world where there's a model which you think is an appropriate approach? Just if you can elucidate on that further, I'd be appreciative.
I'd be really keen to bring in our consultant that we had helped prepare our submission, Michael Jose. He was appearing as a witness today, and he would be happy to provide a response to that. I think, as an outline, we've been talking about a parallel system or an alternative system that focused on mediation and helping families deal with the end of their relationship. All too often, within the adversarial system we currently use, we find that the parents are the subject of allegations of domestic violence, and that's withholding their access to children. It becomes a fighting match over property, access, money, and as an adversarial system, it seems to drag out, particularly when we get the lawyers involved. I think with the focus on mediation, and it's something that's been talked about a number of times in Australia, that the idea that you can support people through their relationships with extended mediation and counselling to deal with drug and alcohol issues, mental health issues, and issues that arise at the end of a relationship, we would be better supporting families moving forward, helping them become better parents, and also supporting their children in a better manner. Again, I'm sort of in a position where Michael has done a lot of research in what's been happening around the world, and I would look forward to ideally seeing him appear as a witness anytime soon.
I think we're trying to get Mr. Jose online still, so if we can't contact him, perhaps you could take that question on notice from me.
Absolutely, thank you. Yeah, as you say, if we can't get him on video, we'll certainly take that question on notice and elaborate.
Yes, we're not. I'm just being advised we aren't able to get him on the phone at the moment, so we'll probably keep trying. But if you take that on notice, because of the time constraints, I'll go to Senator Hanson now.
Thank you very much, Chair. Thanks for your submission. What I want to know is, you mentioned the suicide due to family law. How do you believe it's affected, connected to suicide family law?
The emotional and psychological impact on fathers and on men generally at the end of a relationship is well documented. There's some great research out of Griffith University that's been mentioned in the submission. I know from lived experience it was one of the toughest things I've ever had to experience. When you're dealing with a separation, and then often you have no history of violence or abuse, there's no contact with police, there's no contact with the courts, and you're forced into that situation with an allegation of domestic violence, it can be quite confronting. We've found that many of the men that we speak to talk about anxiety and depression that results from the family separation. That's exacerbated by allegations of domestic violence or abuse. And as I said, when you're put into that position and you're dealing with the domestic violence courts, the magistrates courts, and then you're forced into the family law courts, where there is limited to no emotional, psychological support, we see, and over the last 8 years, we've seen some really terrible stories of self-harm, of fathers harming their children and their partners. So we believe that quite emphatically that there's no separating the facts away from the impact, family separation, and a system that doesn't provide appropriate support all the way through. We believe that it has a significant and contributing factor to men taking their lives.
Do you believe then that fathers take this course because they're so stressed because they've denied the right to see their children? They've done absolutely nothing wrong. There's accusations against them, and it's because of finally they give up hope of ever having that time with their children.
Yes, we do, and I would suggest, based on the research we've been running with our national call number, we took the first 1,000 men that we put into our system and we generated statistics on that, and the level of mental health was above. Men talking to us about their mental health issues and exhibiting what we would consider significant mental health issues was above 70%. The reality that you're pushing people into a system with limited support, you're branding them perpetrators in a domestic violence system that balances everything basically on probabilities with no evidence. You're really putting people up against it, and we see it on a daily basis. And as I mentioned in my opening statements, there was one father just recently who had been in the family court for 9 years, that had dealt with a number of allegations of domestic violence that were proved false. He began having actually issues with a second child to another partner, and because of those issues, he took his life. We see the impact of this system on fathers on a daily basis. And we've raised that a number of times with our political, at a state level, politicians at a federal level with senators about the important need to fund services for men who are dealing with this, because the crisis is real. Particularly, I guess, when you look at the national suicide statistics for men, on average, that's gone up 10% over the last 5 or 6 years. It's something that we believe government doesn't pay enough attention to. And you've only got to spend a little bit of time at the DV courts or the family courts to identify that there are no services there to support men who are dealing with these matters.
Yeah, that's quite evident in your submission that there's no service provided for men. I just want to know, well then, how many men would you do you believe are suiciding due to family law matters a week?
We run a campaign called 21 Fathers, and that campaign's foundation was prior submissions to Senate inquiries by an organisation called the Lone Fathers Association. They would talk specifically about a base number of 3 men a day. We actually did some research prior to launching the campaign, and when we looked at the ABS, it came down to, within the age bracket, approximately 2.8 men a day in that age bracket that you could suggest may have children, could be taking their lives because of these issues. We thought that was a strong enough case to run a campaign based on the numbers that were being used. And since then, we've been overwhelmed by the number of fathers that have contacted us expressing their concerns about the way they're being treated, the emotional and psychological impact it's had on their lives. Interestingly enough, the family court has run some programs and formed committees in the past to discuss this matter in regards to fathers taking their lives. And I think it was a committee back in 2003, Justice LaPaula Trench headed a committee. And because of the findings of that committee, the Family Law Court actually introduced internal training programs for staff as referral programs. We've always found it is interesting talking about male suicide and the connection to child support, domestic violence and family law, because there seems to be really limited research or data that's made available. which we think is just amazing, particularly with the national emergency of suicide in our country.
Yeah.
I know...
I'll ask you a series of questions because I need more short, precise answers. Time is limited and I've got other colleagues who want to ask questions as well. So
Sure.
Then going on, the fact is we know that there's one woman they say is murdered a week. Do you have the stats on men that are murdered by their partners?
I don't have the stats on hand, and I'm happy to take that on notice. What we do know is that this is an unfortunate conversation we seem to have in our country where we're playing off the deaths of women against the deaths of men. I think the death of anyone in a domestic violence incident is unacceptable. From our position, where we're talking about dealing with fathers on a daily basis, we're seeing men who are experiencing significant emotional, psychological and physical violence. We're also talking to families who are losing men in domestic violence incidents. So, I'm hoping that the basis of our submission will help you understand that a narrative that talks about gender and loss of life and domestic violence does none of us any good. We believe that
you are correct in what you're saying, which goes back to, if I look at your page of 26 of your submission, where you did a research online. There was about 1,000 fathers, and you say 53.6% of the males have been physically assaulted by the previous female partner, up to 83.8% being subject to other forms of abuse and domestic violence. And this is not recorded. And as you say, they go to the police. 70.4% of such domestic violence reported to police resulted in no police action. Of those that did report to police, their levels of suicidal identification was higher. So what you're saying is that 90% of men that reported being victims of domestic violence to police received false allegations of domestic violence in return. So that's from your survey?
Yeah, so those statistics are correct, and we're happy to make further. We actually talked about bringing in a professor of psychology to help us better understand the data that we've gathered. We screen men for domestic violence and for mental health issues because it got to the stage for us that when we were talking about why government should deliver these services and how important it was, and we were talking and not getting a response. So we started delivering those services ourselves as best we could. And as I said, the research that's come from that is quite confronting. In no way are we saying that the conversation shouldn't be about female victims of domestic violence and the impact family separation has on women. But we need to, if we're genuine about ending the cycle of violence in our society, domestic violence, and genuine about protecting the welfare of children and keeping families safe, we have to deliver services to everyone. And at the moment, we're not. And the outcome of that, I believe, and I think the research that we've got backs it up, is that we're contributing to the suicide rate of men, and we're contributing significantly to the mental health issues that families are dealing with.
When we've heard evidence of false allegations of being put in before the courts, and even one former judge, David Collier, of the Family Law Court, said there was false allegations of sexual abuse that's being put before him in his courtroom. How should we deal with these with perjury and false allegations? Because purely they've been used against the other partner to stop them actually having access or seeing the children.
Let me bring in Cody Beck. Cody. Yeah, if I can bring in Cody Beck as principal of the law firm, he's dealing with this sort of stuff on a daily basis.
Thank you, Senator. I'm the director of ABF Legal. I've been a practitioner for about 12 years, and we set up ABF Legal about just over 2 years ago. In that time, we've represented in various ways about 500 fathers who are in various parts of the system. What we're constantly seeing at trials, when matter gets to trial, is on the first day of trial, when the mother's about to be cross-examined and have to give evidence under cross-examination, is that all of a sudden, after spending sometimes years making allegations of domestic violence or of sexual misconduct, all of a sudden they want to make a deal with the father for 4, 5 or 6 nights a fortnight. And well, my view on that is and this only comes right at the last minute, right before they have to give evidence, sworn evidence to be cross-examined. If they're telling the truth, they've got nothing to fear from being cross-examined. In my view, the single cheapest and most effective way of putting a stop to a significant degree of these false allegations would be on day one of court for anybody who makes allegations, serious allegations about sexual misconduct or domestic violence, that they should be put in the witness box on day one and be cross-examined, even if it's only for a short period of time. The problem with not doing that and the current system is that you can find fathers who have these allegations. They might be in having supervised contact or no contact for up to 18 months or 2 years. And in that period, they may spend up to and upwards from $100,000 to defend themselves. And unfortunately, a lot of the time when they get in there, they're either running out of money or sometimes they're running out of the will to live before they get there and they get their day in court. If on day one, the person making the allegations was taken to task, I think that the allegations would stop significantly. Mothers and certainly a lot of practitioners know that if an allegation is made now, you're not going to have to answer for it for 18 months or 2 years down the track. And in the meantime, the father may well give up, and a lot of times, unfortunately, do. So I think that'd be the simplest change to the system.
I know that you represent fathers, but there has been false allegations put in by men against their female partners and the mother of their children. So it works both ways here. But to deal with it, then again, if you've got a sexual allegation and it's put in an affidavit and it comes before the family law court, the sexual allegation is a criminal offence and it should be actually thoroughly investigated by the police. Charges should be laid, if that be the case, not just based on an affidavit put before the courts. It should be thoroughly investigated and charges laid, and that's taken before a magistrates court to then be dealt with there, and then it should be sorted out there before it goes before the family law court, which denies the parent access to the child, to see the child. Would that be the way to handle it?
Yes, I believe so. Things need quickly and given priority, because otherwise that can be done very quickly in those courts. Unfortunately, with the family court, you've got 18 months to 2 years. In the meantime, dad's having little or no time with the children, so that'd be a much better way to deal with it.
I think one of the should be looked after. Yes, to look at. Yeah. I mean, the child's protection is paramount in this, but we've got to come down and find recommendations how to deal with the perjury and lies that are being put before the court to deny parents access to the children. Do you agree with the ALRC's recommendations, the 60 recommendations, and if not, which ones don't you agree with?
We've focused on a number of those recommendations, and the things that sort of pop out to us are and I might actually let you, because we were just talking about this.
Yeah, so the two big concerning recommendations in that were to reverse the current assumption that shared parental responsibility and shared care is the starting position for the court. The current legislation, that's where the court should start. And the ALRC recommendations that not be the starting position. So that's concerning for us. In our view, which you should always start with an assumption that that's the best interest of the children, and then if there are factors that lead the court to believe that's not the case, then so be it. But it shouldn't be a starting position. While I don't think it's been dealt with specifically, if they're not going to support starting at a shared parental responsibility and shared care arrangement, presumably the starting position is that children have all the time with the mother, and we just don't think that that's appropriate.
I guess the other one, sorry, Pauline, I think the other one that came up there was the ability for the aggrieved, I think it was the reference to torts, that the aggrieved, on the basis of getting a protection order, the aggrieved could seek damages against the respondent. We think that's particularly concerning, particularly with the volume of allegations that are being made in domestic violence courts. With the expanded definition, of course, you can raise concerns that you're a victim. You can make an application online. You don't have to provide any evidence and an order can be made, particularly in Queensland. We're seeing that the legislation, the Act is written and deems women vulnerable, but it seems the only person left out of who can be deemed vulnerable are white men, Caucasian men. And we see that issuing protection orders based on the balance of probability and not actually testing evidence is allowing perpetrators to get off, often when they consent without admission, and it's forcing people into a position where often when they're poorly represented, that they're making bad decisions from day one, and finding themselves not being able to see their children simply because someone said that they didn't like the way they were spoken to, or there were text messages that they were unhappy about. The courts in Queensland, and no doubt the entire country, are filled with frivolous allegations that are being used to better the position of a parent in the family law courts when it comes to accessing property or children, and we're really not doing any service to our society by allowing it to continue.
I am aware of a victim service in New South Wales where if an allegation of domestic violence has been laid against someone or child sexual abuse, even though it's not been proven in the courts whatsoever, that the perpetrator or the alleged perpetrator is then sent a bill to pay compensation to the victim, not based on evidence. Do we have anything like that in Queensland that you're aware of?
We do, unfortunately. I was contacted by a police prosecutor, Queensland police prosecutor. She raised concerns that applications for protection orders were being made. With the temporary order in place, then an allegation of a breach was being made, and then when with the breach being accepted by the courts or the police charging with the breach, that same aggrieved was making an application for victims of crimes payments. When the payment was received, then the breach was that they would recant the breach, and no further action was taken. And we've had a number of police. The police sitting in the audience with us today. We've had a number of police raise concerns that the domestic violence courts, the system is being manipulated, particularly in relation to family law matters, and that's referenced in our submission. We had one incident where a senior police officer who was tasked with contacting the respondents and notifying them that they had an appearance date was advised by advocates and court staff to delay notification so they would miss the first appearance, which would often put the respondent on the back foot because a temporary order would be in place. One of the incidents that was referenced mentioned that the aggrieved was upset at police because she was assured by her solicitor that the protection order would be put in place because she needed it for her family court matter. So the occurrence of allegations being made and police not notifying the respondent until after the first hearing is all too common. And that is greatly concerning us. And police were saying that they view that as a miscarriage of justice, deflecting access to the courts. And again, that's why it's part of our submission. There are some serious issues that we need to fix.
Just very quick, because I've got to hand this over to someone else. Is that victims of crime in both states, is that federal government funding paying or state?
It's my understanding it's a state issue.
States are paying it. Has your organisation, Brotherhood of Fathers, applied to the government for grants or funding, and have you received anything? If not, why not?
We haven't per se applied for funding. We've partnered with a non-gendered domestic violence charity, End All Domestic Violence. They have applied for different grant opportunities. Unfortunately, with the level of service we provide, we've been unsuccessful in a lot of applications. we would, from memory, I think there's the odd community volunteer grant that they've received. I think there was a state government grant that they accessed to provide crisis accommodation, limited crisis accommodation. But through End All Domestic Violence, I know that we've raised concerns about better mental health support. We've raised concerns at a state and federal level about the need for improved crisis accommodation. And again, it's police that are talking to us saying we desperately need to provide services for men, particularly perpetrators that they're dealing with, that they can't provide adequate services to, which is again concerning. I think the other issue there is we were really keen to be able to provide better legal advice to men, because often if you can provide good legal advice and initial support to men, they can navigate their way through DV matters and family law matters pretty well. Unfortunately, when ABF Legal, and I might throw that over to you, Cody.
Yeah, sure. So we made an application to go on the legal aid panel, and we were refused that because in the correspondence they said that they looked at our website and our Facebook page, and because we're deemed by them a gendered service, we wouldn't be able to go on the legal aid panel. So we can't provide any legal aid type services. So anyone who comes to see us, unless we can help them out on a pro bono basis, then they're paying private legal fees, which, as everybody knows, can be quite substantial.
And the demand on our service is extensive. So to be able to access funding through the charity and to provide better crisis accommodation, court support programs, I think would go a long way toward intervening and preventing ongoing domestic violence issues.
You're saying that you're actually denied some funding because you're gender-based.
Yes.
That's right.
We have other services that are basically women's services that get their funding, and that's not classified as gender-based.
No, that's right. So it would seem that way. So Queensland Women's Legal Service, I believe, are given about $4 million or thereabouts.
I think last financial year it was $3 million.
$3 million by the government. So, but we're not able to get anything. And if they call themselves Women's Legal Services, clearly it's also a gendered service.
Right. Thank you very much for your evidence, Chair. I'll hand back to you.
Mr. Perrott.
Thanks, Chair, and thanks for your evidence, Mr. Beck, Mr. Erikson and Ms. Bowshire. Your submission asks for the creation of a family law commission, and I think you say, and I quote, to undertake inquiries on systematic issues in relation to family law associated services. Are you aware that there is currently a statutory body that has the power to do those things? It's called the Family Law Council. It hasn't actually had any members since 2016. Have you advocated with politicians to have that actual Family Law Council resourced and functioning?
I myself wasn't aware of the Family Law Council, and if I understand Michael Jose is available via phone, and I'm sure he'd be happy to answer that question or take it on notice. Are you there, Michael?
I don't think. I think we got a message saying that he wasn't online. But so we'll get a response, written response later down the track. Sure. Your submission also asks that, and I quote, "Admission without consent be removed as an option in family violence orders." And this might be a question for Mr. Beck or Ms. Bowshire as the solicitors either side of you, Mr.
I'm happy to field that one just initially. With the amount of time that we've spent at the domestic violence courts, what we're seeing is it's almost
hold on. Let me ask the question before you answer.
Sure.
I assume you actually mean consent without admission, rather than admission without consent. But can I just clarify if that's actually what you mean? You know, it's where a family violence order is made by consent and without the person making any admission.
That's correct. That's what it refers to. Consent without admissions, yeah.
All right. And are you aware that the Family Law Act provides as one of the additional considerations in determining the best interests of the child, which is section 60cc subsection 3k, that when a family violence order is in place or has been in place, the court can take into account the circumstances in which the order was made, any evidence admitted at the time, and any findings made by the court when the order was made. That is, if an order was made by consent and without admission, that would be taken into account by the court. It sort of contradicts some of the evidence you heard earlier, some of the questions you heard earlier.
So I just didn't sort of understand what the actual question was.
Your submission is talking about consent without admission, you know, where, you know, the scenario might be, you know, she came over to, you know, she came within 100 metres of my property. So, you know, I went and got the family violence order, but they're not actually admitting anything. They're just saying, all right, well, let's do a deal. And we did that because we were picking up the kids because of, you know, school sport or something like that. Sure. So it's a consent without admission of anything.
Yeah, so sure. let me start, because the issue we're seeing is we look at that as a get out of jail card, basically. At a state level, you're given 4 options. Basically, when you appear on a DV matter, you can look to take an undertaking. You can consent to the order. You can consent without admission, or you can take it to a hearing. Yeah. Our belief is that consenting without admission is allowing perpetrators to get away with the act, and all too often we see it on a regular basis that you can consent without admission to it. If police do not charge you with an offence, you can sail off into the rest of your life without any finding of facts against you, and continue on to potentially commit the same acts against other people. We would prefer that any allegation being made be examined and have evidence tested before the courts, allowing someone to have an order put in place. And all too common, when that order is made, if there's the duty lawyers dealing with 50 people, they will ask questions along the lines of, do you want to see her again? Is the relationship over? And in the heat of the moment, we're finding men who are poorly advised will consent without admission and not fully understand the impact that has on their life. Of course, by doing that, the order's put in place. All it takes then is for a text message or an allegation, another allegation that may be baseless, to create a breach, and that breach can then very well turn into a criminal conviction. I'm not sure that consenting without admission is actually, apart from getting people out of the court system quickly, is actually addressing the issue of domestic violence in our society. Cody, did you want to add to that?
No, I think you've covered.
That's okay. Yeah, I might go to the National Accreditation of Private Family Report Writers, and your submission, I asked, would that be similar to the current accreditation system for family dispute resolution practitioners? And are you aware of that system? And the Attorney General's Department keeps a list of the practitioners who are accredited. Would you like to make comment on that?
That would be an area for Michael. That's his expertise, and we'd take that question on notice if we could.
Okay. You also suggest that judicial vacancies should be advertised and applicants assessed, and your submission says, against core competencies and experience. Do you agree that family courts should have specialist judges?
Yes, they should. It's such an important area of law, and it can affect people's lives, not only parents, but more importantly, children's life for such a long period of time for the rest of their life, basically what happens when they're a child. It's vital that those judges sitting on those matters are experienced in and know that area of law back to front. I don't think anybody could argue with that.
So, you think that in an advertising process would locate such people?
Well, I think the issue that Michael would be referring to in that submission relates to the vacancies that are currently there. That there are backlogs in the family law court
Yeah.
that relate to judges not being available to hear the matters. And if we're not drawing on a pool of replacements that are suitably qualified, then what is the Attorney General's office doing to rectify that? Does it require? Do we need to get more people in there?
Okay, my next question is to do with support services for men generally. You touched on it in your opening statements and in your submission. You say, I think I actually wrote down the exact quote, that you said that there were no services for men. We've certainly heard, we've had witnesses in your position that detail the services they provide for men, and certainly in Queensland we've heard of Men's Helpline and the like. Do you recommend those for men, or is it always you try to go through the actual is it? I assume ABF is a for-profit legal firm like any other legal firm?
We don't actively encourage people to call Men's Line. The feedback we get regularly from men that do call Men's Line is that they're deemed perpetrators when they're called. We've raised those concerns a number of times. I've actually spoken to support workers at the Family Court and the Magistrates Court about what services are available to men. And the conversation generally goes, it depends on who you talk to. If you talk to a government-funded organisation, they will tell you that there are services available for men dealing with this stuff. When we actually see what's happening on the ground, they're quite limited. And I guess that's why the volume of inquiry we get is so high, because men have made contact with either Beyond Blue, Lifeline, Men's Line, DB Connect, asking for support when they're victims of domestic violence, and they're questioned about their role as perpetrators. And I think you would agree that if you're reaching out for help and being deemed a perpetrator of domestic violence at the same time, you would be put off by that service.
I'm not sure if you saw the Hansard of the witness, the services that actually provide these services, because it certainly contradicted what you're saying, that they talked about programs that were available for men. But look, I might move on to another question. And you actually, so I just need to clarify in terms of the lawyers there. Does ABF provide services for women as well, or is it only for men?
No, we provide also services for women, because we're reaching out. We're predominantly here to try and help fathers, but we do have several female clients, though. And we have several female solicitors on staff.
Okay, so because I think you were suggesting that all services, that all legislation and services should be gender neutral was your suggestion.
That's
and
okay, we focus on men. We do so because that's what I know. As a man and from my own lived experience, we see there's a gap in service delivery. At the same time, we believe that any services that are delivered are gender neutral. And in saying that, when we have mothers call us, and they do, grandmothers, mothers, that we provide us the same level of service that we provide to fathers. The only difference is we don't record their statistics in our database.
Okay, so because we have heard overwhelming evidence that although men may be victims of family violence, women are far more likely to experience violence from an intimate partner. The statistics we were presenting was that it's basically 3 times more likely. And so can I just ask you if you agree that it is far more common for women to experience violence from an intimate partner than men?
Well, the latest research out of Queensland, one of the universities that we've referenced in the submission, has indicated that between 30 and 50% of victims of intimate partner violence are men. So at best 50, is it? At best 50. And really it comes down to, I think, and this is again pointing towards a narrative where we're only focused on female victims, that the research isn't being done, and men aren't being encouraged to report. And what we're seeing with our own data is that the vast majority of men that we speak to talk about being victims of domestic violence, and often it goes unreported. There's no denying that women are victims of domestic violence, and there's no denying that we need to do more to support women in crisis that are dealing with violence. That doesn't mean that we shouldn't provide the same level of support and services for men.
Okay, and I just wanted, my last question is either to Mr. Beck or Ms. Bowshire in terms of cross-examination. Just before I go there, I just did want to point out that Women's Legal Service Queensland do not get legal aid funding, so I'm not sure.
No, they don't. They get specific funding federally.
Okay.
I think last year, 1.5 million from the feds and 1.5 million from the state. So they get a specific allegation to provide services only for women.
All right. Now, my question, it is to Mr. Beck, and a comment you made in terms of the first part of any process should be putting the person claiming to be a victim through cross-examination. Mr. Beck, that was your suggestion. Is it your position that every person you have encountered making such a claim has lied? Because you said that they all should be cross-examined.
Yes, anybody who's making a claim of severe domestic violence or sexual misconduct on the other party should have to be cross-examined and have to give evidence under oath on the first day. It's not because we're saying that, and I'm saying that goes both ways, whether it be the mother or the father. If a person makes those allegations, they should be taken to task on it on day one, not 2 years down the track, where in a lot of cases the other party's given up in the meantime. I think that was a lot of
could you see that? Could you see that potentially, and irrespective of the gender, being traumatic for the victim?
Well, they get cross-examined at the end of the process in any event, and obviously, in order to get to the truth, cross-examination is the only way that can happen. So, does it make any difference whether it's at the end of the process or at the start of the process? Certainly, it makes a difference for children who, in the 2 years intervening period, don't know one of their parents. Makes a difference for them.
And certainly the cost that's enforced upon parents who are involved in family law matters, protracted matters that go over many years, costing many hundreds of thousands of dollars, impact the family in a terrible way. Removing the financial base of families through the family law system is disgraceful. So to test the evidence initially and work out whether there's any validity in the allegations that are being made, I think are really important.
If we have time at the end, I have several examples here of cases we've dealt with.
Miss Bowshire, would you like to add further to that in terms of your experience as a practitioner in terms of cross-examining people?
Only to add that, to just emphasise what Mr. Beck has said in relation to, in specific cases where if the evidence isn't tested at the first court appearance, the court will inevitably act cautiously. So you do have cases, and we do have examples of cases where a particular parent might be on supervised time for 2 years. Then when the evidence is tested at trial, the roles are completely reversed and the child is placed with the parent who the allegations were made against in the first instance.
Okay, all right. Thanks very much for your evidence.
Before I go to Ms. Stegel, I understand that Mr. Joseph is online now.
Yes, I am online. My apologies. There were some technical issues, but I can hear and hopefully speak.
That's all right. Just for the Hansard record, can I just ask you to state your name?
Sorry, my name is Michael Jose, Jose.
Thank you very much. I'll now go to Ms. Stegel.
Thank you. One of the areas you've touched on is the interrelation between our local court system that generally deals with the domestic violence at first instance, when that's where they will first appear, and then the impact they have in family law, in the family court proceedings. From your database and your experience, is it, and you touched on the situation of parties making admissions without, consenting to orders without admission in relation to AVOs. Is it overwhelmingly that happens in situations where there is no legal aid or a pro bono or duty solicitor available at those courts to actually give some advice to those parties?
From my experience where I've sat with duty lawyers, it seems to be the go-to consideration. This is the advice that you should accept. You know, you don't want to see her anymore. The relationship is over. So if you can consent without admissions, we can get you out of here quickly. It becomes an almost tick and flick sort of scenario. I have heard stories where there are no duty lawyers available in magistrates' courts, that it comes down to the magistrate providing direction to the respondent. And I think it's quite telling when, as I said earlier, that when you've never had contact with police and you've never been before the courts and you were there being asked to consider accepting an order without any clear legal advice, you know, and the fact that that order can then have lifelong lasting issues in regards to how you access your children, it should be a concern for all of us.
So in
Additionally,
those
Leith,
situations,
you'll find it both on the Legal Aid website plus the Magistrates Court's website, and a video that they also have uploaded. They try and direct you down the path of consenting without admission. And I additionally believe there's a further issue in relation to defendants of ABOs cannot access legal aid.
Okay, so so when in terms of the you say the system is encouraging you down that pathway. I mean, I'm a past practitioner. My experience of the local courts is they're generally very overworked and a too busy a list. So do you think that comes down to change that? It would be resourcing at the local courts as well to ensure they're not trying to process through cases quickly by encouraging consent without admission?
Absolutely. I think in some jurisdictions it represents a substantial amount of the Magistrates Court day-to-day business now. It is bread and butter for some magistrates in various jurisdictions, and obviously the court would like to reduce that number. The difficulty is consenting without admissions, as Leith alluded to, has some serious ramifications, both in relation to the family court and obviously potential criminal issues and exclusion from home, assets, and most importantly children for extended periods of time.
Yeah, and look, I mean, as Mr. Perrott raised, the Family Law Act does provide for the family court to consider the ways in which those orders are made. So if they're made by consent without admission, that's considered. But you know, we've certainly had a lot of evidence in relation to the ongoing effects of orders in the local court in relation to domestic and family violence having an impact on family court proceedings. So is a solution to that from a starting point that there be duty lawyers or legal aid available to parties at the local court level when it comes to domestic violence?
Just to jump in there, I think staffing is absolutely an issue, and while I don't necessarily want to point towards funding more lawyers, I think that's an important part of it, particularly in areas that don't currently have access to duty lawyers. I think the bigger issue there is how do we want to deal with perpetrators of domestic violence? Do we want to hold them to account? And I don't believe consent without admission does that. I also believe it allows some aggrieved to make false allegations of domestic violence to better their position in family law matters. So to be able to test the evidence every time an allegation is made, maybe that's the solution to weed out false allegations. That somebody's going to have to actually back up the allegations they make, and maybe that's the change we need to see, so there's more funding available for real victims.
Okay, I guess what I would put the difficulty with that though is one of the big issues we've had before us has been the delays and the time it takes between local court proceedings and family court proceedings. The delayed disputes are extended over, really multiplies the impacts on the family dynamics. So if all proceedings at local court were defended in that way, that would take, my experience was it takes 3 months to get a listing, another 3 months before the prosecutors have got their case together. You're lucky to get a hearing within 12 months. So the problem is that does add to the delay these proceedings then take on.
I guess if I can just jump in there, I guess sort of what we're saying is that the allegations either need to be consented to as they are, essentially as if you would plead guilty to a criminal charge. You're agreeing to the facts as they are presented, or they're taken to trial. This current system where they're consent without admissions, they're in effect pleading guilty but with not accepting any culpability, that greys it up for sort of both sides of the argument, I guess.
And the concerning thing for us is we see male perpetrators. We see men who are doing the wrong thing, who are consenting without admission and not being held accountable for their actions. And for us, we believe we have a duty of care to everyone we come in contact. So that father has a wife or a partner that had children. If they're perpetrators, we need to hold them account. And I've seen instances where there have been women who have been in contact with police a number of times as perpetrators, who have done terrible things to children and fathers and never been held to account simply because they've consented without admission. And if we're serious about ending the cycle of violence in our society, how can you continue to let these people get off simply because the legal system is overwhelmed to be able to deal with it?
So when we get to, I know there's a difficulty with legal aid when it comes to AVOs, but in the family court system, there's a lot of unrepresented litigants, and we have heard some evidence that does cause delays as well, and also creates a problem of lack of understanding of the basis on which the court is looking at certain questions and what's sort of being, or what, managing expectations of what can be achieved. So do you see as a way forward that really, if legal aid is available to parties in the family court process, it really should be both sides to ensure we don't have one person legally aided and one person unrepresented, and then we have a real, disjointed process?
Yes, if that would certainly help. It would help with time delays, unrepresented parties. There's always delays, there's always adjournments and things like that. So having both people represented competently would certainly help with some of those delays, in my view. And
do you, in relation to another area we've had a lot of evidence on has been in intimate partner and violence, there is the financial control aspect as well. And that there's been a lot of allegations or frustration with parties bringing, using the court process, as an abusive process, like repeated applications, really with especially if parties are legally represented, then it's seen as a financial control tool because you're forcing the other party to continually incur a lot of costs. Do you have any recommendations around that? In relation to how many applications a party should be able to make to the court.
Once you're within the system, the only means of actioning is through the application process. So I think the process needs to be able to be facilitated. The cost element is a concern. But once one party has possession of the assets, the house and the children, the other party really only has a recourse through the court system at that time.
Okay, I'm not speaking specifically in terms of property cases, but we've certainly had evidence of parties being repeatedly taken back to court for minor things and across both genders. This is not a gender thing. So, and that, of course, then delays the court process. So do you have any recommendations around, for example, having a tighter framework or time frame around how many applications parties can make to try and bring things to resolution quicker?
There shouldn't be any restriction. If the parties... Sorry, Cody.
You go, Michael.
I was going to say, there shouldn't be any restrictions in relation to applications. I mean, the parties should be moving towards either less adversarial means of negotiation or moving towards a situation where they can start to agree or consent to disagreements over minor factors. As I said, if one party is controlling all of the assets, the house and the children, the only avenue available is through the court if they're not willing to be cooperative. We shouldn't put an arbitrary restriction in relation to that application process. There are already concerns in relation to applications and potential cost ramifications. So I believe the system has a means of addressing superfluous or excessive amounts of applications.
Okay. So is it your view that the current sort of cost order process in the family court is sufficient? Because one issue we've also had a lot of is non-compliance with orders when it comes to timeframes for producing documents or financial statements and the like. So is there enough in the current system in terms of the court's ability to make cost orders? Do you consider that to be sufficient?
I'll jump in there. The short answer is no, it's not sufficient. It's not used anywhere near enough by the judges. You're right. People often flout orders. They don't comply with them in a timely manner, and then there's adjournments and things like that. And sometimes that can be a tactic by one side. Some solicitors are well known for those kind of tactics to try and run the other person out of money. And cost orders aren't used anywhere near enough, in my view. They're pretty much never used in parenting matters, and they're only very rarely used in property matters. So I believe it would fall back onto the judges. It would be a bit of a change in policy there, and a change in guidance for them to start using those more readily, and that information be broadly spread through the profession, so that people are on notice that if they're going to essentially play these little games that are going to cost people money, that they're at a real risk of paying legal fees that are as a result of that.
Okay, thank you. Thank you for your evidence.
Dr. Ali.
Thank you, Chair. Can everybody hear me?
Yes.
Yes.
Oh, good. Thank you. And thank you for coming in and for your evidence and for your very comprehensive submission. I just have maybe around 4 questions and some things that I want to explore with you. And the first one is just following on about the question that Mr. Perrott asked about cross-examination that Mr. Beck and Ms. Bowshire responded to. And I guess I understand the logic behind what you're both saying with regards to that time frame, that 2-year time frame, and the fact that, somebody could be prevented from having a relationship with their children for that 2-year time frame until a matter is heard. But I also understand the point that Mr. Perrott is making around concerns around cross-examination being re-traumatising, the fact that somebody who has experienced some very traumatising levels of domestic violence, it can be very, very daunting. So I want to ask you, what is a third solution? What's a way that we can deal with both of these issues, the issues that you raised and the issues that Mr. Perrott has raised in his questioning as well?
From my part, that's something I probably wouldn't want to respond to off the cuff. It's something I'd have to give some thought to. So I'd have to take that one on notice.
Would you be able to do that? Would you be able to perhaps, give some thought around that and craft a third option?
Yep.
In my experience, having worked with both state and federal justice agencies and implemented technology and process projects in relation to vulnerable witnesses, there are already mechanisms in place to reduce the trauma and the difficulties faced by such witnesses. By way of example, in the family court, they've now excluded people that have been accused of domestic violence incidents from cross-examining complainants. That is in place, I believe, across the entire country now. Additionally, there's opportunities to potentially provide evidence remotely or by video conferencing. That was a project I implemented in New South Wales some 10, 15 years ago, so that they don't have to face the individuals that they've made complaints in relation to, and reduces, obviously, intimidation. There's also the the discretion of the presiding judge to ensure that cross-examination is done in a manner that's respectful and not going to re-traumatise the victim.
Thank you. Thank you so much. Mr. Erikson, you've mentioned several times throughout your submission and today in the hearing services for men and support services for men. Can I ask, first of all, does your organisation provide any services? What are they? And then what kinds of services would you like to see?
So for us, we started a court support program and would send volunteers off to court and act as Mackenzie friends or just be with someone if they were self-representing. We also were getting a lot of calls from people who didn't understand the system and were concerned after speaking to Men's Line and other organisations that they were being portrayed as perpetrators. So we started 1-800-FATHER as a free call national service. And as I said, with that, we screen for domestic violence issues and we screen for mental health. We explain to them how they can get hold of a mental health plan if they need to, and we have a follow-up service attached to that. So if they're unable to fund a legal fund a matter before the courts, that we have volunteers with lived experience that help them fill out forms, and we provide templates and guides. And often, particularly with men, they struggle using technology at times. They struggle to be able to type out what they're dealing with in the form of affidavits, so they tend to require a bit of support there. We also have partnered with a DV charity, End All DV, to provide limited crisis accommodation. It's something that we speak to police about quite often. Service providers around the country do have limited access to beds. Often police are telling us that perpetrators are told to leave their home on an ouster order and they have nowhere to go. They don't know where to send them. And I was only in a meeting with the DV task force locally a week or so ago where they expressed great concern for how they were going to support men and help them not re-offend when they couldn't. So a little that we do. As I said, we've also started a law firm, and Cody runs the law firm for us. Services we'd like to see. We see the mental health issues as a huge factor in ongoing domestic violence. The fact that there are very limited services that we see when guys attend the magistrates courts, and I'm there on a regular basis. So often, whether you're an aggrieved or whether you're a respondent, you will sit in the open gallery. There are times there where we've had to say to court staff that we're concerned about the welfare of men that are there. Women tend to be provided with safe rooms or separate parts of the court buildings where they don't have access to the respondent in their matter. So to provide better support services and facilities in-house for male victims would be a good thing. I think a particular focus on mental health is really, really important. And we could look at that at the family law courts, the magistrates courts, when they come in contact with police. A really common thing we're hearing is that you've got, in Queensland, for instance, you've got the vulnerable persons unit attached to the DV liaison officer, and they can make referrals for services. Often the feedback we've had from men is that they're concerned about dealing with police moving forward. They feel like they've been treated unfairly at times. I know that often we go to police stations as well, and we sit with men and when they're interviewed, and I've got to tell you, we do it regularly, and each time it's confronting. Police generally run the narrative that women are victims, men are perpetrators. So when male victims do turn up seeking support, it's quite distressing when they're turned away. And we see that as again, a significant contributor to mental health issues and suicide. We have anecdotal evidence from families that have suggested that the family members have had contact with police in DV matters, family law matters, and then taken their lives. So I guess if you could think about whatever services are available for women at the courts and in the community, and the focus that's been placed on that, we believe we should be focusing the same amount of support on men. Particularly if, again, it comes back to if you're hoping to end the cycle of violence in our society, that you need to deliver services and support to perpetrators. And that's a really common feedback from police, general duties police and police and DV task force, that they're saying we need to do more to treat them with respect, help them change direction in their life, and provide, again, very, very basic services.
Just on that point, if I could just jump in quickly, there's a men's behavioural change program which is which runs throughout Queensland, and similar programs throughout Australia. Certainly around southeast Queensland, there's about a 6-month wait list to get into that program, and then it takes about they vary between about 16 and 26 weeks. So it's quite a long period of time before a perpetrator can sort of get that help and get some guidance and better ways of dealing with anger and things like that. So that's a massive issue that we're hearing all the time.
And the irony of that is that often when a protection order is made, that the court will request that these men do that behavioural change program, and often that can be a precursor to having access to their children, is that they complete the course. I've only recently completed a facilitator's course in Central Queensland University, and that was one of the things that came up. A lot of the attendees of that course were probation parole, and they were saying it's all well and good to stipulate that perpetrators have to go and do these behavioural change programs, but if government doesn't actively fund the program so it's readily available, it sort of has us questioning whether they're serious about ending that cycle of violence and intervening.
And you mentioned that you screen the men, predominantly men who come to you to see if they are perpetrators, and would you then refer them onto a men's behaviour change program, or how would you deal with somebody who, when you screened them, it was revealed that indeed they were a perpetrator?
Sure. So we screen men for domestic violence, and our concern is what their experiences are. During that screening process, if we hear that they've been abusive themselves, we'll counsel them on behaviours that would be expected, and that if that behaviour continued, that there would be a very good chance that they wouldn't have access to their children. So we come at it from a zero tolerance approach to violence. It's often difficult with the delays in accessing a program, that for us to refer someone on for support to deal with domestic violence and their behaviours, if you've got to wait for a 6-month program and you're court ordered, your opportunity to access that program is pretty limited if you haven't been court ordered. We're actively working to change that. We've started men's groups that we run on a weekly basis, and we want to engage in a conversation about what men are experiencing, and as we do that, ideally train facilitators so that we can start including behavioural change programs of a sort. Some of the feedback that we've had in regards to those programs is they're demasculating almost, that you have to sort of start saying that you're a perpetrator, and that unless you fit in with that a narrative that any violence that was experienced in the relationship that the male was responsible for, often men are either asked to leave the program or deemed that they've been unsuccessful in the program. I think there's a smarter way for us to deliver those types of programs. And sure, we need to hold people accountable for their actions, but from our perspective, we see it as a really important tool to help men understand that an end of a relationship that has involved domestic violence is an opportunity for them to be better men, to be better parents, better fathers. And I sort of question any program that focuses on the Duluth model, for example, where it only focuses on female victims, male perpetrators. I don't think there's anything positive to come from that. And I think, again, it sort of cycles back. If we're serious about ending the cycle of violence, you need to look at both sides of what people are dealing with. A lot of the men who talk to us about domestic violence also talk about reciprocal violence, particularly emotional and psychological violence and abuse. So, yeah.
Okay. So I do take your point about the training and the programs and the delivery of these programs. I imagine, though, that you would completely agree that people with sufficient training in the delivery of these programs and sufficient training in and understanding of behaviour change should be running these programs, right?
I think there should be some oversight in programs, and I know that again, if based on that format, you would need clinical oversight, and you would also need interaction with the victim, and also a case management there of type, and that would be really important to ensure that the victim understands how the perpetrator is doing within the program, and particularly where there are children involved and they're pending family law matters or orders that rely on the perpetrator to have completed the course successfully. I absolutely agree that they need to be run by qualified people. You got to question it, but that there are long delays. You've got 6 months, 9 month delays to access a program. It sort of makes you sort of wonder whether government is serious about ending the cycle of violence and serious about changing behaviours when they won't deliver the funding for it.
I just have one more question for you, please, and it's just around, I don't think anyone's asked the questions and we haven't really explored it thus far, around your question, your recommendations around child support reform, which is the final bit of your recommendations there. And the last one that you've got there is around outstanding child debts to be cleared. Can you please explain to me the logic behind that recommendation?
Yeah, so from my own personal experience, I was withheld access to my children, and my partner, the mother of my children, did that deliberately to maximise the amount of child support she received. Often, and we only were talking to gentlemen in group last night who were accruing debts based on capacity to earn. So if you're employed and your income reduces or you change jobs, that the agency can deem that you have the capacity to do that work and that you will be assessed based on that income, even though the income might have reduced. And people are accruing debt because of that. I don't think that there's any benefit to enforce debt recovery on child support based on calculations that are unfounded. And we've got pretty good evidence to suggest that the child support system has failed significantly and has allowed parents to profit with their children, to maximise the time that they have, or to minimise the time that a payer has. And I know from my own personal experience that it placed me in a position where significant debt that I am unable to pay, and I don't see the benefit to society for doing that.
What about the benefit to the children in having, a parent contributing to things like school fees and, we all know.
I think it's really important. I also think it's really important that those children have access to the parent themselves. And that seems to be one of the critical issues here, is that the system rewards one parent who withholds access. And that happens on a regular basis. And often the number that comes up is 126 days. If you can, particularly where there's welfare involved, where the mother might be receiving welfare, that she will limit the amount of time that the father or the payer has access to the child specifically, so it doesn't impact her support payments.
So, Erikson, I understand what you're saying here. So the recommendations, if I can just clarify, the recommendations you're making are based on situations where child support is used as a way of preventing access, or access is prevented in order to increase child support. So the recommendations that you're making are in relation to the relationship between the amount of child support paid and access?
Yes, we actually believe that the child support system has failed significantly, and that it's better served to be able to cap payments and reward parents who co-parent, rather than reward parents who limit access based on the amount of money they can make either out of welfare or out of the paying parent.
Okay, so let me put it to you that we completely remove that part of it and think about child support just in terms of the amount of money that it takes to raise a child and contributions to raise a child. I completely understand the recommendations that you're making are in relation to that, the way that the way that it can be used to prevent access and vice versa. But if we were to talk about the needs of a child and focus only on what's best for the child, would then you consider perhaps that some of the recommendations that you're making are not in the best interests of a child? For example, capped payments, for example, the removal of outstanding debts. And if I may say this, as somebody who had a 15-year outstanding debt and ended up having to write it off just to move on.
Sure. So I guess to answer the question, I would ask a question. Did your children miss out because of the debt? Do you believe that your children...
Yes, I raised my two sons on $400 a fortnight without a cent from their father. So yes, they did miss out. But my personal experience aside, we did have the Child Support Agency come back to us on how many debts they do actually clear or expunge every year, and it's in the vicinity of about 300 debts are expunged or written off every year. So it does happen.
Are those debts just in relation to that? Can I ask in regards to expunging debt? Are those debts expunged because the payer has passed away, or are they?
Provided that information about the reasons for expunging debt. All I can say is that I have experience and I have heard cases of debts being expunged because they are, 15-year debts, where it gets to a point where, in my case, it got to a point where I had, gone back to university, built myself up, got a good job, and ended up earning more than him, and then child support saying, you now have to pay him, or we can write off his debt, and then nobody has to pay anybody. Sure.
So we would recommend a system that, again, rewards parents who ideally co-parent. If a parent doesn't want to co-parent and doesn't want to see their children, maybe there's an option there that they would, whatever their tax return is or taxable income, how it's whatever returns are generated from that could be contributed to the care of the children. I know it's always difficult, and I know that the last parliamentary inquiry into the child support system didn't actually produce the sort of outcomes people were looking for, because we're still dealing with a system that, and it happens daily, that income changes and assessments stay the same. And particularly early in relationship issues where the father has left the home and is required to pay child support, required to pay the mortgage, still required to keep the family in the living standards that they're accustomed to together, but then he can't manage his own financial affairs because of those requirements. Include domestic violence issues there, and a failure to meet those obligations suddenly become a breach or financial abuse. So, I think there's a lot of work to be done with the child support system. I know 2 boys, as a self-employed businessman, 2 young boys who grew up without their father because their mother, who was left with the property, all the commercial assets, chose to use it as a weapon against me. Horrendous. I'm here because of these 2 children that grew up without a father. So I can relate absolutely to what you've experienced yourself. I'm on the other side of that. And because of that, I've spent the last 8 years volunteering to see reform.
Yeah.
It's also worth noting the suicide rate amongst child support payer fathers is double the rate of Australian males who do not have administrative child support assessment.
I'm sorry, Mr. Jones, can you please say that again? I missed that from the beginning.
Apologies. I just wanted to point out also that the suicide rate amongst child support paying fathers is double the suicide rates of Australian males who do not have administrative child support assessments. That is a significant anomaly.
I have no further questions, but I do just want to end on one point. Mr. Erikson, you said that, child support is used about rewarding parents. I just want to end on the point that I don't think child support should be about rewarding parents. It should be about raising children. And I think that maybe that's the reason why we need that, the recommendations that you made. If child support is being used as a reward for parents, then that needs to change.
Yeah, I agree.
Thank you. Thank you all for your submission and for appearing today. And thank you, Chair. I have no further questions.
Senator Polly.
Yes, thank you, Chair. And also your submission is very detailed, but I wanted to just continue on from where Ms Ali left off, and that's in relation to child support reform. Paternity testing before a payment agreement can be made, that's one of your recommendations. I was just wondering why you see a necessity for paternity testing. Isn't that, again, adding another cost and a delay?
No, there's been a number of cases that we've seen come across our desk where fathers have paid child support as the legislation suggests, and they've then spent a couple of years in the family courts only to find that the children that they've been seeking access to aren't theirs, the children that they've been paying for. Not only do we would like to see paternity testing with child support, we'd actually like to see paternity testing for anyone that enters the family court. The stories of families spending tens of thousands, sometimes hundreds of thousands of dollars in the family court, only to find that the children aren't theirs, and claiming child support for children that are not biological children seems to be a fairly, while infrequent, it happens enough for us to raise that as a concern in our submission.
Can I just ask then, can I just then want to seek clarification? So if the paternity was unknown to be anything else than the biological child of that father, and that they've been in that household for 10 years, 12 years, and they've raised that child, from your point of view, there is no moral obligation to continue to make payment and child support, because for all intents and purposes, there would have been obviously a relationship with that child. So what I'm reading from what you've written in your submission and what you've just said is, if it is then proven 10 years later that that child is not mine, I shouldn't have to pay for them.
There are circumstances where fathers have found out the children aren't theirs biologically.
I can see that.
Still want to maintain a relationship and are happy to pay for the children. I think it falls in line with the motivations of some parents who want to hide the paternity of children potentially, and then I think if we're going to be serious about holding people accountable for their actions and their behaviour, that particularly where there's financial incentive involved, I know as a father I would want to know whether it be at the beginning of proceedings or the beginning of payment that the kids were actually mine. I think it would be up to the individual then to decide whether they want to continue paying, but we believe that's an important part of this process. And I'm sure that, if you do a simple Google search, you'll find a number of cases where the children weren't biological children, and there'd been property settlement, there'd been a large amount of money paid, and it all based on a lie.
Thank you. Look, we have limited time, and lots of questions that I was going to ask have already been dealt with, but I just want to go to the area, and you quite often have given evidence today if we want to get serious about domestic violence and about violence. But in your recommendations and your submission, you refer to domestic violence as, and I quote, review of the research underpinning the domestic violence industry. What do you mean by domestic violence industry? Because I take one interpretation of that. I'll give you the opportunity to clarify what you mean by industry.
Well, we see that a narrative that only focuses on female victims and provides services to only female victims, and a conversation both politically within the media that revolves around the need for only funding services for women would be classed as an industry. What really saddens us is that we see the death of men and children almost going unreported at times, yet we see the death of women and children in domestic violence incidences in some sections almost celebrated by, and it's macabre at times that the media and politicians, some politicians, will fly a flag of vulnerable women and how important it is that we only fund those services, and it leaves many of us thinking that the money is focused specifically not just on victims, female victims of domestic violence, but almost to fund a feminist narrative in Australia. And it's often, particularly when you have organisations like White Ribbon, organisations like Our Watch, that rely specifically on government funding and only talk about one side of the conversation.
Mr. Erikson, would you not agree that family violence and domestic violence was grossly underreported, and by shining a light through an organisation like White Ribbon, which you've called for that to be abolished, has actually brought into focus the Australian community that any violence, whether it's perpetrated against a man or a woman, is unacceptable, and without those organisations we would not even be having that conversation today?
As a victim of domestic violence myself, I found that White Ribbon was disgraceful. To ask men to stand up and take an oath, and I was put in that position as a victim myself of female perpetrated violence. I have never been more offended by it. In note of White Ribbon, I find it interesting that an organisation like that can be phoenixed after being run into the ground with the use of taxpayer funds. It's my understanding, and that's what leads us to the belief that there's an industry built on the suffering of women that I believe isn't doing a very good job. If we were genuinely serious about ending the cycle of violence in our society, you would be delivering the same level of services and support to men and women, and we're not doing that.
And they'd also be stepping away from the gender-based narrative and addressing all forms of domestic
Erikson,
violence.
that is an issue that you and I will agree on, and that is there needs to be more funding by governments at all levels to address violence in our community, whether that's domestic violence or family violence.
Senator, with all due respect, I don't think it's just a funding issue. It's the conversation we have in our society.
Well, it's an education that should happen in schools, so both genders actually have more respect for one another, and that's where the time that we're actually going to be able to change society's attitude towards violence.
The federal government has funded a national campaign that has blamed only boys, men and fathers for domestic violence in Australia. It is absolutely disgraceful. We should be talking about
that's your evidence. That's your evidence. I obviously don't agree with that. But when you were talking about services for men and going to courts, and there's additional breakout rooms and support facilities for women, can you give us some evidence as to when a male domestic violence victim or any male has felt threatened by having to share a waiting room with their former spouse, has been refused a breakout room that hasn't been necessitated by not having that space? So
yes, I've actually been in the magistrates' courts where we've asked for access and have been told that there was none available. I was actually
Can you name those courts? Can you name those courts?
Yep, Southport Magistrates Court. I was actually only there a couple of days ago with an aggrieved father, and I was prevented from accessing a room with him as his support person. It's happened a couple of times to me personally, where the aggrieved duty lawyer has turned away supports a person for a male. I find it amazing, and I'm actually in a position now where we tend not to make too much noise about it in the courts, because we would rather come in, provide the support and leave without too much notice. In the past, when I've raised those issues, that we've had the media sort of jumping down us, and we've had government-funded representatives from organisations who are basically calling us liars. I've seen men cowering in the corner of courtrooms while their respondent partners, female partners, have stood close by with representation. It's really disturbing to see it happen, and the fact that I'm seeing it on the few times that I do go to the Magistrates Court, I can only imagine what is actually happening in other places around the country. Would you also then agree, because we've had evidence, and I know my own family law court in the city where I'm based, there is just not enough rooms for any victims to be able to have those breakout rooms, so that it could very well be that there's just lack of facilities generally that needs to be addressed in this country, rather than one that you say is based on gender. Well, when we talk about lack of facilities, the state government in Queensland, as part of their not now, not ever domestic violence policy, at the Southport Magistrates Court, spent $3 million outfitting space on the first floor of the courthouse specifically for women, with no male access to services.
Just on that area, the area that Leith's referring to, I've been to the Southport Magistrates Court a lot. I've been there in circumstances where I'm with the aggrieved, who's a male, and we've asked for rooms, and they said, "Oh, we can't offer you anything," and we've sort of gone up to the other end of the of that first floor, in circumstances where we've got the respondent, who's a female, she's in the protected room, and her family members are outside that room laughing and poking fun at my client and things like that. But also there's been occasions when I've asked to go into the women's protection room to either speak to, there was one occasion where I wanted to speak to one of my clients who was in there, and there was a couple of occasions where I wanted to speak to the other side or the other side's duty lawyer, and as a solicitor, I've been refused access into that room. And those facilities are massive. It takes up a big chunk of that first floor. I don't see why a portion of that couldn't be apportioned to men, because there's certainly nothing there at the moment.
Can I then put another question in relation to, we've had a lot of evidence today and throughout these proceedings in relation to the serious nature of family and domestic violence in this country. So, and I think you've also concurred in your evidence that there is an issue in this country. Can I then ask why in your submission, when you talk about the definition of domestic violence, how you want to interpret and put people in categories as to the severity of the violence that they've endured, when we've had a lot of evidence which is contrary to that, who say that whether it's psychological or physical or whether it's controlling behaviour, that that sort of behaviour is damaging. And yet in your submission, you want to categorise violence. Can you explain
I'm happy to talk to that,
why?
please.
Yeah, jump in, Michael.
Okay, so we've proposed a tiered definition, and this is supported by some of the research that we've referred to within our submission. One of the key takeaways was from the 2005 paper from Johnson, which said that it's no longer scientifically or ethically acceptable to speak of domestic violence without specifying loudly and clearly the type of violence to which we refer. Now, at every change of the definition of domestic violence at both state and federal level, it attempts to include more and more activities. Now, within those activities are obviously very, very damaging long-term controlling behaviours, including physical violence. And at the other end of the spectrum, it includes everything from financial abuse right down to much less severe activities that are not uncommon in the breakup or the acrimonious breakup of a dissolution of a relationship or a marriage. Now, our concern is that it doesn't tier those sorts of activities between severity. So once the domestic violence classification has been triggered, whether it's from two couples treating each other badly, shouting at each other, cold treatments, maybe throwing things, maybe trying to access their phone, the lower end of bad behaviours, they can also trigger the domestic violence process in relation to the family court itself, in relation to the Family Law Act, in relation to things such as mediation, in relation to things such as ABOs. And they're bunched in together with obviously very severe and very damaging activities. And once the domestic violence system is triggered, all those protective mechanisms come into place, which can see that the person who's responding to those allegations may not be getting access to their children and their assets in their home. That is our concern. So we're actually suggesting that there should be, as a part of that initial urgent assessment process that Mr. Beck referred to, there should be a tiering of the severity of those domestic violence allegations and action, and that is supported by the research.
Thank you very much. I'll leave my questioning at that point. Thank you, Chair.
So we have Senator Waters and then Dr. Martin.
Thanks, Chair. Your submission talks a lot about the delays and the costs involved in family law proceedings, which a lot of other witnesses have also raised. The Law Reform Commission made a number of detailed recommendations about increasing funding, streamlining entry processes and so forth. What do you think are the priority actions to reduce delay in the court?
Michael, did you want to have a go?
Yes, I can. We have a three-tiered approach in relation to our recommendations. One is we believe that there should be certain things done in the interim in relation to oversight commissions and also gathering extra data and research. The second is we actually suggest that we should have a completely alternate model, particularly in relation to parenting cases, where the adversarial model is incredibly harmful and damaging specifically to children. The third is we advise reforms in relation to the existing system, and we've got quite a lot of detail in relation to that. Certainly, we concur that one of the biggest issues around the existing system is the issue around delay, and perhaps additional funding in relation to resources across the entire spectrum of the family law industry, including members of the judiciary, may attempt to alleviate what is one of the gravest concerns, that is the delay of going through the system. But in essence, we state that we don't believe there's much merit to be throwing money at a system that we think is fundamentally flawed, particularly in relation to parenting matters. So if more funding is going to be assigned, it is to reform or fix some of the issues with the existing system, but we believe the primary solution, particularly in relation to parenting, is to get it out of the adversarial system. The other difficulty we have is in our submission we've identified many issues with the existing system, and some of them go right through to the legal profession itself. We believe just giving more money to the entire system is just going to more extensively impact the community in relation to the system, the systemic issues with the existing system.
Well, in relation to restricting the exemptions to mediation, do you acknowledge that mediation is unlikely to be effective where one party feels intimidated by the other?
I believe, yes, we do, and I believe there are mechanisms in place in relation to that. There are exceptions to going through the mediation process, the Section 60I certificate. But we also believe that that Section 60I certificate is too easily and too readily obtained. We provided statistics in our submission indicating that a large or sizable amount of matters does not go through the mediation process. We believe there should be more emphasis in relation to mediation being the first step, and techniques and processes applied to make it effective where there may be an imbalance of power. We also believe where one party is absolutely not committed to that process, that is more impactful in relation to how family court proceedings proceed.
Can I just jump in quickly? Just in relation to mediations, the majority of them, and these days I'd say almost all of mediations, are conducted on what's called a shuttle basis, where one party, and if they've got a lawyer, will be in one room, the other party and their lawyer in the other room, and the mediator walks between the two rooms, and the parties never see each other the entire day. It's not as though, it's not the way that I guess it used to be, and certainly when I first started practicing, we had a lot more matters where we'd all be sat around a table. That's almost non-existent now, so there's less of that, I guess, undue influence that it could be said by one party to the other.
With the allegation of domestic violence where a temporary order might be in place, if the parties are booked in for mediation with Relationships Australia, the mediator may just simply because there's an allegation of domestic violence and a temporary order in place, that they will deem mediation not suitable. And it's almost as if, again, that the allegation of DV can be used to circumvent the need to discuss important issues and force the matter before the family courts.
Well, on that theme, you've called for mandatory penalties, including sentences for giving false statements. A number of other witnesses to this inquiry have said that the amount of women who make false allegations of violence is infinitely less than the number of men that falsely deny violence. So would your proposal apply equally to any party found to have made false statements?
I think it's important to hold people accountable for their actions, and if those actions include lying, then absolutely. And we come at this, and this is the issue that we tend to have, because we talk about the experiences of fathers, and we're called the Australian Brotherhood of Fathers. There's this misconception that we want to give men a free ride when it comes to doing the wrong thing, and that's certainly not the case. We want to hold parents accountable for their behaviour to ensure that our children are supported and protected through the separation process, and that everybody's safe and healthy moving forward. We believe that's important for us to have a healthy, successful society. At the moment, if the system is bogged down, and it's bogged down with allegations that can't be substantiated. The definition is so broad now, of course, that simply saying that you're in fear of someone without producing any evidence or a history of domestic violence is enough to get an order. The amount of money that's been spent there, surely there needs to be some sort of change. Surely if you held people accountable for allegations that they're making that can be proved to be false, that we should be looking to remove them from the system to free up resources for real victims.
Right. Well,
Senator
I don't accept that women make up allegations of violence, so I suspect we probably won't come to a meeting of minds on that one.
So just on that point, can I interject? Because we have a lot of content in our submission on exactly that issue. And we've tiered it across a number of different topics and headings or the opinions of various industry stakeholders. So in a study that was done in 2011, the opinion of family law practitioners, they state that false allegations of intimate partner violence were made in between 30 to 80% of cases. Also, there have been JudCom studies that were done of obviously judicial members, both in New South Wales and Queensland. New South Wales, the members of the judiciary, best placed to make this assumption or assessment. 90% of them said that AVO orders were often thought as tactical devices. In Queensland, 74% said that they were often used for tactical purposes, and those JudCom surveys also made reference to the ripeness of false allegations. We have obviously the input from police officers, which is off the record. We've also made reference to extensive amounts of surveys and research that was done of members of the community in relation to their impressions of false allegations throughout the family law industry. And also I'd like to finally make reference to a recent UK issue where they removed legal aid in matters where there were no domestic violence accusations, and the result of that is there was a 30% rise in domestic violence orders made after the legal aid was axed. In some of the regions in England, the increase was as much as 900% or 150% in various other regions. We believe that false allegations are what is making a mockery of the jurisdiction of the family court system.
Have you read the evidence that was presented to this inquiry in previous hearings? I don't have the names of the witnesses to hand, but it'll be on the Hansard for this inquiry. There are a number of practitioners and academics, and we discussed this very issue with them and put to them what was their view of the numbers of women that made allegations that were false. And their evidence, very strongly put, was that, as I said in my original question, that the numbers of men denying violence was far more than the numbers of women making it up. I'm just interested in whether you took the time to read the evidence, the submissions and the Hansard of the evidence that they gave to this inquiry.
Yes, indeed I have. I've also, of course, read the research, which is often referred to in some of the other submissions, which in my understanding doesn't actually support their claim, saying the research says that false allegations are rare. Two of the pieces of research commonly referred to in both Australia and Canada actually say the complete opposite. And you've made reference to the Hansard contribution of some other contributors to the Senate inquiry. As I said, I've quoted both the opinions of legal practitioners in the family law system and the judiciary who are making decisions in relation to these areas, and the consensus is in those cases that the false allegations are extraordinarily common.
Okay, well, look, you'll forgive me for going off the folk with the expertise in that field. So I accept that you are citing different research that may have different methods of it being gathered, but we'll go off the evidence that's presented to us in the inquiry. Can I just finish off by asking, I note that you mentioned you've set up some services, helplines, legal assistance. Who funds your organisation?
We're self-funded, Senator. As you'd probably be aware, there's limited resources made available to men in Australia, particularly when they're dealing with domestic violence matters and family law matters. We see the failure of government as the reason why we're here. we've spoken many times with stakeholders about how important it is to deliver services, only to see nothing happened. So we were lucky enough to put together a model that allowed us to self-fund to deliver those. The majority of people in our services are volunteers, and they have lived experience of false allegations, being victims of domestic violence at the hands of women, and having been forced through a family law system that has effectively cost them their life savings and stolen their children.
So when you say self-fund, do you mean the organisers, you are contributing from your own pocket, or are you asking for contributions from the people to whom you provide assistance?
Did you want to jump in here?
The law firm is a private law firm. As I mentioned, we can't get legal aid and we don't get any government funding or anything. So people are paying private fees to us, and then the firm makes, I guess, donations back to the organisation to allow them to run run the support programs that they run.
So for the charity that we've set up, End All Domestic Violence, the shop front for us was the law firm, and that law firm donates to charity to deliver crisis accommodation, the phone support service, and the court support program. And we do that pretty well with fairly limited funds. Again, we'd asked the question a number of times of both Labor and Liberal politicians about accessing funding to deliver services, and it proved to be particularly difficult.
Thanks very much. Thank you, Chair.
Dr. Martin.
Oh, thank you, and thank you for your submission. My question is in relation to the recommendation summary, and in particular the research that you've listed in your submission. I commend you for focusing on research. I think it's very important because it informs and guides our decisions, particularly in clinical practice, and sets benchmarks. However, I couldn't help but notice the lack of focus on children in terms of research. Particularly, research focused on things like, getting the best outcomes for children or adolescents who are caught up in a family law dispute or in custody disputes, and looking at factors like the age of the child, the length of time children may be separated from one parent during a dispute or ongoingly during the period of their childhood, and also the interactions and communications between parents that are caught up in the dispute, and the impact that has on the parent-child relationship. Would you be able to comment on that?
Leith, did you want to talk to that?
Sure. Yeah, absolutely.
Look, I believe we have substantial content in our submission in relation to children and how they're impacted in the system, and that's in a multi-tiered manner. First of all, our recommendations that we take parenting out of an adversarial process, I think, is child-centric and child-focused, and we go into some grave detail in relation to how the adversarial system does not serve the parents and does not serve the children. Also, within our document, we talk about the harm that the system causes, and we have much content in relation to how children are affected mentally by being on the periphery of conflicted or parents going through the adversarial family court system.
I think my point is that there is a lack of research in this area on how to make decisions about the best outcomes for children caught up in child custody disputes, and that you didn't have that recommendation on your research list. And would you be willing to add that to your recommendation on your research?
Absolutely. and we mean nothing by that potential admission, definitely in assessing the harm and obviously focusing on the best interests of the children, we would want to include that as one of the focal points for any future research. Also in relation to that is, of course, we've listed details on how the current system doesn't basically emphasise enough the children's views, and in the Australian system, particularly compared to overseas systems, children within our system don't feel that they have a say, that they aren't represented, and they're not aware enough of how the process is proceeding and how it might impact them.
Now, I'm going to raise something else. You were talking about domestic violence earlier. Someone raised the issue, and I think I'm not sure who it was that made the comments, but basically somebody had commented that you screen individuals who come into contact with your organisation. And my question to you is, who screens the individuals, men who come into contact with your organisation for domestic violence? And is it self-report?
It is based on self-reporting, and I can sure you can understand the difficulties we'll have dealing with people on the phone that are calling us from all over the country. We run a really strong case management process with good follow-up. So when we do screen them for domestic violence, there's a set number of questions that we'll ask that will talk about emotional, psychological, physical, controlling behaviour, contact with family members, contact with children. We also ask them about their experiences if they've contacted police for support, and also what sort of services that they've reached out to, whether it be Lifeline, Beyond Blue, Dads in Distress, or Men's Line. So we record all that information. In regard to the people who are screening it, they're volunteers. As a small organisation, we rely heavily on volunteers. We provide our volunteers with pretty good training in-house, and we've been actively seeking to have our program be overseen by a particular professor in Wollongong University, associate professor of psychology, and it's through those screening processes that we've seen some really troubling statistics around the experiences of men dealing with domestic violence, and also their mental health issues associated with that. There's a lot more we'd like to do.
So just to summarise, your screening, I'm not sure I understand how the screening tool was developed, but it seems to be standardised. Is that right? It's the same set of questions that you present to. It
is the same set of questions.
That's organisation.
That is correct. It's the same set of questions, and everyone that calls us, we screen them.
Okay, and the screening, the questions were developed by who? Or
we developed them in-house with the support of some counsellors and psychologists that we were talking to, and I'll acknowledge that we would like to do a lot more work with that. We're kind of limited with the sort of funding that we have access to bring people in to help us with that, and we're actively working on that. But yeah, so standardised set of questions that tries to work through the entire depth of the definitions of domestic violence that it seems to be standardised now
So the questions, the people that come in are given this questionnaire, it's handed to them and they complete it on their own, or are they in an interview situation with a trained volunteer?
Yeah, it's an interview process.
Okay. All right. Now, one of the other questions I had was that you suggested before that you provided counselling to individuals in your program. Is the counselling standardised, or is that just ad hoc, and who provides the counselling?
Often with volunteers, particularly if men are calling us asking for support in regards to DV or family law matters, volunteers that we use have lived experience. so they can often talk about what their process was and how they went through it. We did, over time, have psychologists in-house that we would, and counsellors working with us or volunteering with us that we would refer on to.
When you say lived experience, are you saying people who have changed their behaviours and previously engaged in behaviour that would be considered domestic violence?
I think the majority of our volunteers I would deem as victims. I can't off the top of my head say that we've actually had anyone volunteering with us that has been deemed a perpetrator of domestic violence. Not saying that that wouldn't be the case. I guess I'm interested where you're going with that, because if you're suggesting that we're coaching people on behaviours or something along those lines, that would be a concern for us, because we approach what we do from a position of zero tolerance. The reason for screening these men is to ensure that we provide them with the support that they may require, and if we can't provide that support, we refer them on to support services, and that's something that happens on a daily basis, I can assure you.
Okay, so the victims, so previous victims of domestic violence who have, as you say, lived experience of providing counselling to men who are identifying as having engaged in domestic violence. Is that what you're suggesting?
Well, in regards to framing it as counselling, if they were speaking to someone who was providing counselling, in that scenario they would be trained counsellors, qualified counsellors. The same if they were speaking to someone providing them mental health support, they would be qualified psychologists. In regards to volunteers providing advice and support from their lived experience position, that's what it would be. Now, again, whether they are people who are calling us, whether they are perpetrators or victims, our job is to offer support and advice. And ideally, if they are perpetrators, to help them understand that behaviour is unacceptable and not conducive to matters that would give them access to their children unsupervised or help them through the family law system. We're in a position where we're kind of stuck, because often these men that call us have spoken to other service providers and feel like that they're not getting the support that they need. And we try not to judge people. As I said, we provided advice and guidance based on lived experience, and we find it particularly successful.
Have you got any outcome studies to measure the success of your service?
We don't, but in saying that, we have actively been investigating clinical oversight so we can do more research. The research pool we started with was the first 1,000 men that contacted us, which is a significant pool. So the only thing holding us up is our ability to access funding to do that. I have spoken to government at different levels. We've also approached the primary health network in regards to providing better qualified services in-house. And it's something that we're genuinely concerned about, because a large percentage of the men we're speaking to talk about mental health issues that they're struggling with.
Previously, you mentioned a relationship with the university. I think you said Wollongong University. You had some support and guidance from some professor from the University of Wollongong. Can I suggest you build on that partnership to develop an outcome study, because that's very important when we're evaluating the success of programs.
I agree, and those conversations had taken place before COVID had shut us down, and we're actively seeking to move forward with that. And as I said, it's just the issues of funding that that limit our ability to partner with the university. There is a cost that's been mentioned to have that clinical oversight, and they're very keen to do the work with us. And I'm sure over the next 6 months that will happen. But yeah, I agree. It's something that needs to happen.
Thank you for your question, for your responses, and thank you for your submission. No further questions, Chair. Chair?
Well, apparently the chair's not there. Is any other
Sorry,
questions?
I was on mute.
All right, you're there. Okay.
Mr. Erikson, Mr. Beck, Ms. Bowshire and Mr. Jose, thank you for your detailed submission, and thank you for the discussion of it in some detail today. We appreciate it. For those questions on notice, if you can forward the answers to the Secretariat, we'd appreciate that.
Okay, thank you for the opportunity to provide evidence.
Thank you.
Thank you.
Thank you.
The committee will now suspend hearings until 2:15 p.m.